Hello, and thanks for joining us. I'm Larry Levitt, Executive Vice President for Health Policy at KFF. Tomorrow, the Supreme Court will hear a case to overturn the Affordable Care Act. The case started as a legal long shot, but is now before a newly configured and more conservative Supreme Court. More than a decade after its passage, the ACA is fully embedded in our healthcare system. Nearly everyone has been affected in some way, from no-cost flu shots to pre-existing condition coverage and expanded Medicaid eligibility. There have also been tax increases to fund those benefits. Overturning the ACA would create chaos in the healthcare system and political chaos as well in the scramble to pick up the pieces as millions lose coverage in the midst of a pandemic. Nearly every political leader says they support preserving protections for people with pre-existing conditions, but there's no bipartisan consensus on how to do that. And there are many parts of the ACA beyond pre-existing condition protections. President Trump and his administration have supported the lawsuit rather than the typical stance of defending the ACA as a federal law. President-elect Biden made supporting and building on the ACA a centerpiece of his campaign, but he cannot literally make the suit go away. Congress could make the suit moot with one of several simple legislative fixes, but control of the Senate is up in the air as 2 seats go to runoffs in January. The future of the ACA could depend crucially on the 2 Senate races in Georgia. We're going to begin with several short presentations followed by Q&A. First, Mary Beth Musumeci, an attorney and associate director of our program in Medicaid and the Uninsured, will explain the case and what to watch for in the oral arguments. Next, Robin Rudowitz, co-director of our Medicaid program, will assess what overturning the ACA would mean for Medicaid coverage and states. And finally, Cynthia Cox, who heads up our ACA program, will talk about the implications for people with pre-existing conditions and the main other ways invalidating the ACA would affect all Americans. As they're speaking, feel free to jump in with questions using the Q&A function at the bottom, and we'll get to as many of them as we can after the presentations. So Mary Beth, I'll turn it over to you.
Great, thanks, Larry. So this case is a challenge, another challenge to the constitutionality of the ACA's individual mandate, now that the associated financial penalty was set to 0 by Congress. And the big question is, if the mandate is unconstitutional, whether the mandate is then severable from the rest of the law, or whether instead the entire law has to be struck down. Like other challenges to the ACA, these arguments initially were not expected to get very far, but they have in fact gotten some traction with the Supreme Court hearing argument tomorrow. So who's involved in this case? This slide shows a map with 18 states led by Republican attorneys general or governors, headed up by Texas, and these are the states that are challenging the ACA. There are also 2 individuals who purchased marketplace coverage challenging the ACA, and they sued the federal government, but we'll talk a little bit more about the federal government's position in a moment. A group of now 21 Democratic state attorneys general led by California intervened in the case to defend the ACA. And on appeal, the US House of Representatives also intervened to defend the law. These parties intervened, next slide please, because notably the federal, that one, yes, thanks. So the Democratic states and the House intervened because the federal government is not defending the constitutionality of the mandate. And this is notable because it is unusual for the federal government not to defend the constitutionality of a federal law. So you can see on the square on the left shows you the parties' positions as the case was filed, but on the right, you'll see that with the federal government's position in practice being challenging the law or not defending the law, it's important to have California and the House involved, because if not, there would not be a party defending the ACA. Next slide, please. So the Supreme Court is going to decide several questions. And if you look at the upper left of the boxes where the yellow boxes start here, the first question is a procedural one. Does at least one state or one of the individual plaintiffs have standing? This is the legal ability to bring the case. And the question is whether, in fact, these individuals are injured legally by having to purchase marketplace coverage, or with the other choice of essentially doing nothing by paying a penalty of $0, or whether the states actually are injured by the existence of the mandate. if assuming the court answers that question affirmatively, the next question is the mandate constitutional? The Supreme Court upheld the mandate in 2012 as a constitutional exercise of the taxing power. The challengers, however, now say that that argument no longer holds after the 2017 Tax Cuts and Jobs Act set the penalty at 0. A trial judge in Texas, as well as 2 of 3 judges on the Fifth Circuit Court of Appeals, accepted this argument. If the court finds the mandate unconstitutional, it then needs to decide whether the rest of the ACA can survive without it. And this is really the question that everyone is watching. The presumption is that the rest of the law should survive if the mandate's unconstitutional. The Fifth Circuit, however, found that the trial judge's analysis on this issue was incomplete. The federal government, interestingly, has changed its position multiple times during the litigation. Now, at the Supreme Court, the federal government is arguing that the entire ACA should be found invalid as a legal matter. However, it does not necessarily want the court to prevent it from still enforcing parts of the law. Instead, the federal government is seeking a more limited remedy, asking the court to prohibit it from enforcing only provisions that are found to harm the 2 individual plaintiffs. The government has not clearly identified which specific provisions fall into this category, and instead is asking the court to send the case back to the lower courts to determine that issue. So what's important to watch tomorrow? We can watch for the areas that the justices focus their questions on. For example, do they ask about the procedural standing issue or not? And this will give us some indication of their current thinking. However, nothing is certain about the outcome of the case until the court issues its written opinion, which is expected sometime by the end of the term in June. Until that point, the ACA remains in effect, and the Trump administration has said throughout the litigation that it will continue to enforce the law while the case is pending. Now that we have President-elect Biden, there's an additional question about the federal government's position in the case. Tomorrow, the Trump administration will be arguing. After the argument is over, the case is officially ready for the court to decide, and that decision could come anytime between now and the end of the term. It's not likely, though, that we'll see a decision before the inauguration in January. So in that case, a new Biden administration could let the court know that they've changed position. But because there are still Texas and the individual plaintiffs on the other side arguing for the entire law to be struck down, having a new administration with a new legal position won't moot the case out. In terms of its decision, the court could decide all of the issues before it, or it could agree that the mandate is unconstitutional, but send the case back to the lower courts for additional analysis on severability as the administration is asking. And that decision then could potentially come back up to the Supreme Court in the future. Another question is what happens if the court sets aside all or part of the law? When does that decision take effect? Typically, decisions are effective when they're issued. It's possible, but probably unlikely, that the court would make its decision effective sometime in the future to provide some time to unwind the ACA. And now I'll turn the discussion over to my colleague, Robin Grudowitz, to talk about some of the implications of losing the ACA, particularly for Medicaid.
Great, thank you, Mary Beth. And as she just said, I'm going to turn to some of the implications of overturning the ACA for Medicaid. So the ACA Medicaid expansion was designed to fill in gaps in Medicaid coverage that existed prior to the ACA and also provide enhanced federal matching dollars to states to provide that coverage. Before the ACA, people had to meet both income standards as well as fit into a specific category of covered groups to be eligible. These groups included low-income children, some parents, pregnant women, adults with disabilities, and some elderly. This left many adults without coverage because eligibility levels for parents were very low, and adults without dependent children had no pathway to coverage through Medicaid without a special waiver, even if they had zero income. The ACA extended Medicaid eligibility to nearly all adults with incomes up to 138% of the poverty level and effectively eliminated these categorical eligibility requirements. The ACA also included enhanced federal matching dollars for the expansion group. There was 100% federal match from 2014 through 2016, and then that phased down to 90% in 2020, where it will remain going forward. This is higher than the traditional match rate in all states. Next slide. After the Supreme Court ruling in 2012, states effectively had the option about whether to implement the Medicaid expansion. As of today, 39 states, including DC, have adopted the Medicaid expansion. That includes 2 states that adopted expansion through a ballot measure over the summer, Oklahoma and Missouri, and those states are set to implement the expansion in 2021. This leaves 12 states that have not adopted the expansion. And in these states, median eligibility for parents is about 41% of the federal poverty. That's less than $9,000 annually for a family of 3. And in these states, except for Wisconsin, adults without dependent children are not eligible for coverage. And this leaves about 2 million people in what we call a coverage gap, where they're not eligible for Medicaid and they're also not eligible for subsidies to purchase coverage in the marketplace. Next slide. We have done a comprehensive literature review of the effects of the Medicaid expansion that includes over 400 studies. The studies largely show positive effects across a number of outcomes, including access and utilization, coverage, payer mix, and financial affordability. We also did a subsequent review that shows that expansion has helped to narrow racial disparities in coverage. Next slide. So as was said before, a decision to overturn the ACA would have profound implications across the healthcare system. For Medicaid, it would mean a number of things. At least 15 million adults currently covered by Medicaid could lose coverage. This includes 12 million people that were made newly eligible by the ACA and about 3 million people that had pre-ACA coverage through a waiver. About $80 billion in enhanced federal matching funds would also be at risk. To continue coverage for adults without dependent children, states would have to seek another waiver, or they would have to use state-only funds to provide that coverage and adopt state-only programs. States could extend eligibility for some parents, but without the enhanced match rate, so that would be financially difficult for states. Most adults who lose Medicaid coverage would likely become uninsured. Though most adults on Medicaid work, few have access to employer coverage. Private coverage is prohibitively expensive for low-income people. In addition, individuals who lose income, jobs, and employer coverage due to the economic downturn would have fewer coverage options available to them. And finally, an estimated 4 in 10 adults with Medicaid have pre-existing conditions and would not be able to access private insurance without those pre-existing protections. And with that, I'm going to segue and turn it over to Cynthia.
Thanks so much, Robin. So first, I'm going to start out by talking about the individual market, and then I will also go into more detail in a minute about kind of all of the other ways that the ACA affects our healthcare system. So first, looking at the individual market, this is where people go to buy health insurance when they don't get it through work or Medicare or Medicaid. Now, more than 1 in 4 adults in the US has a pre-existing condition that would have left them uninsurable in the pre-ACA individual market. Before the ACA, insurers in this market generally wouldn't cover people who had heart conditions, diabetes, cancer, or other chronic or high-cost conditions. They also wouldn't cover pregnant women. Above and beyond this 27% of people who had declinable pre-existing conditions, there were many others who had conditions like depression or even acne, where they might not have been denied coverage, but they were probably charged higher premiums or faced benefit exclusions. Now, in the world of coronavirus, we'd also expect a recent COVID diagnosis to be considered a pre-existing condition. So this isn't even included in this 27% number. Also, there's maybe 4 in 10 adults from recent surveys that show that this many people have symptoms of depression or anxiety disorder. So there could be many more people who have pre-existing conditions now because of COVID and the resulting effects of the pandemic. At any given time, most people aren't purchasing coverage through the individual market, but as the pandemic economy has demonstrated, people can lose job-based coverage at the drop of a hat. And before the ACA, it was very difficult, if not impossible, for many people to maintain coverage if they lost their jobs. Okay, moving on to the next slide. So some people have asked, if the ACA is overturned, can't states just pass their own laws requiring insurers to cover pre-existing conditions? And wouldn't that solve everything? The short answer is no, that wouldn't really work. The longer answer is that in order to protect pre-existing conditions in the same ways that the ACA does, states would need to do much more than simply mandating that insurers enroll people who have pre-existing conditions. For example, states would also need to require essential health benefits to be covered. They would need to limit out-of-pocket costs, limit the ways in which premiums can vary. And all of this makes health insurance more expensive. Because insurers have to pay out more medical claims, they would have to cover their costs by raising premiums. To offset the resulting higher premiums from covering pre-existing conditions fully, the ACA includes generous subsidies or tax credits that make insurance affordable for those who qualify for this financial help. Floridians, for example, receive almost $10 billion in premium tax credits. Californians receive about $7 billion in premium tax credits, plus billions more from Medicaid expansion. And the reality is that states simply don't have this kind of money in their budgets to replace federal spending, even in the best of times, much less at a time when budgets are already strained from the pandemic and the recession. Also, because of a law called ERISA, states don't have the legal authority over self-funded employer plans, which is how about 6 in 10 people who have job-based coverage get health insurance. So states wouldn't be able to, for those people, they wouldn't be able to, for example, prohibit lifetime caps or annual limits, which were commonplace before the ACA. All right, we'll go to the next slide. So when people think about the ACA or Obamacare, we often think about Medicaid expansion or the individual market, which includes healthcare.gov and exchange markets. We also think about pre-existing conditions. But what a lot of people may not realize is that the ACA goes much farther than that. The ACA's reforms affect nearly every American in some way. Not only did the ACA expand coverage to about 25 million Americans through the exchanges, Medicaid expansion, and letting young adults stay on their parents' plans, the law also fundamentally changed private insurance market rules in ways that affect people who already had insurance before the ACA. For example, the ACA prohibits employer plans from imposing annual and lifetime limits on coverage. It sets out-of-pocket maximums. It sets benefit mandates called essential health benefits. It also has made preventive services, including contraceptives, free of copayment, which has lowered costs for millions of people. The ACA also reduces out-of-pocket liability for seniors on Medicare who take expensive prescription drugs, and it even includes other provisions like calorie labeling or approval of lower-cost pharmaceuticals called biosimilars. So if the ACA is overturned without a replacement plan, this would send the healthcare system into total chaos. Millions of people would lose coverage, and every player in the health industry, which is almost 20% of the US economy, will need to rethink how they do business. And the timing is such that this could all happen while the pandemic is still raging on. So with that, I'll turn it back to Larry.
Thanks, Cynthia. We'll move on to questions now. And as a reminder, you can submit questions using the Q&A link at the bottom of the screen. And certainly Mary Beth, Robin, and Cynthia are available for questions, as am I. And we have several other KFF experts available to answer questions as well. Tricia Newman, who runs our Medicare program, Alina Salganikoff, who heads up our women's health work, Samantha Artiga, who leads our program on racial equity and health policy, and Ashley Kurtzinger, Associate Director of our polling program. So let me start. We had one question, and Mary Beth, maybe you can take this one, as to whether any of the state plaintiffs who are challenging the ACA are states that have chosen to expand Medicaid under the law.
Sure. So actually half of the Texas-led states, so 9 of the 18 have adopted the Medicaid expansion. They are Arizona, Arkansas, Indiana, Louisiana, Missouri, North Dakota, Nebraska, Utah, and West Virginia. And they, despite having adopted the expansion, they all are taking the position that the entire ACA, including the Medicaid expansion, should be struck down. So I don't know that in their briefs they've actually gotten to the issue that this questioner is asking about whether they've actually justified it, but they say that because the mandate's no longer constitutional, the entire law, including expansion, should fall.
Great, and we had several questions about what Congress could do to make the case moot and how the Georgia Senate runoffs might affect that. And I'll start, and then anyone else who wants to jump in. There are kind of three simple legislative fixes Congress could do to make the court case moot. If you think back to Mary Beth's explanation of the case, one would be to repeal the individual mandate entirely, which would get at the heart of this case. The second would be to make the individual mandate constitutional once again, based on the Supreme Court's previous decision by adding a small tax penalty to the individual mandate. And that doesn't necessarily have to be the amount that was the amount of the penalty that was previously in place under the ACA. And then the third would be to clarify that the rest of the law, the rest of the ACA is severable from the individual mandate in the event the individual mandate is ruled unconstitutional. There are some procedural issues as to how a Democratic majority in the Senate could accomplish these fixes. For example, two of them repealing the individual mandate or clarifying that the rest of the ACA is severable from the individual mandate would likely require 60 votes to overcome a filibuster. The third, adding a tax penalty back to the individual mandate, could likely be done through what's known as budget reconciliation, which would require only a majority vote. But of course, the control of the Senate is up in the air with the two Senate runoffs in Georgia. It's very likely that the outcome of those Senate runoffs could determine control of the Senate and the future fate of the ACA. We had another question about how Republican opposition to the ACA has evolved over time. Ashley, maybe you want to jump in first and talk about how Republican voters have viewed the ACA over time?
Yeah, thank you, Larry. So we've been tracking public opinion on the Affordable Care Act since its passage. And while we have seen a gradual uptick, especially in 2017 when it was looking to be repealed by Congress, we saw a slight uptick in views towards the ACA, but overwhelmingly Republicans and Republican voters still largely disapprove of the Affordable Care Act. We have seen in our most recent tracking poll that Republican voters do not want to see the Supreme Court overturn the ACA's protections for people with pre-existing conditions, which I think gets to what the question was asking about. So we have seen some support among Republican voters for maintaining these protections. But when we ask about overturning the ACA overall, Republican voters still largely want to see the entire ACA overturned.
And I would add, I mean, we have seen some shift in how Republican leaders talk about pre-existing condition protections under the ACA. In this last election and in the midterm elections in 2018, many Republican candidates promised to protect people with pre-existing conditions, but at least so far, there have not been any detailed replacement plans as to how to do that. So I think while there appears to be a consensus around protecting people with pre-existing conditions, there's still no consensus, at least no bipartisan consensus about exactly how to do that. There were several questions about how the pandemic and the economic crisis have affected enrollment in ACA plans. The ACA is here as a safety net for the first time in an economic downturn. Robin, and then maybe Cynthia, can you talk about sort of what evidence we have and what we know and don't know about how the pandemic has affected coverage under the ACA?
Sure. We've been trying to track what's happening with Medicaid enrollment based on national administrative data that CMS puts out. So the data now is through July, or preliminary data through July, and that is showing about a 6% increase in Medicaid enrollment through July as a result of the pandemic, and that's about over 4 million new people coming, or 4 million person increase in Medicaid coverage, and that's stemming from both the maintenance of eligibility protections as well as changes in the economy.
So a big part of the challenge here is that we don't really have a good real-time way of measuring how many people have insurance at this moment in time. So we know that a lot of people lost their jobs. We don't know exactly how many of those people who lost their jobs also lost their health insurance. We had some data that goes through the end of June that suggests that although job losses at that point in time were in the almost 10% range, that as far as the percent of people who had lost employer coverage, that number was maybe more like 1 to 2%. So it seems that at least through midsummer, insurers or employers had probably by and large kept a lot of people who had been furloughed on their health plans. But we've seen that more recently there's been an uptick in permanent job losses as opposed to temporary job loss or furlough. And so with that increase in permanent job loss, we would expect that more people might be losing their employer coverage. And if that's the case, then we also have other analysis that shows that the vast majority of those people who are losing job-based coverage would qualify under the ACA for either expanded Medicaid or exchange programs in their state. So the ACA, as Larry said, is there as a safety net. We're not sure yet exactly how much of a safety net there needs to be right now.
Thanks. We also had a question about how the ACA affected contraceptive coverage and maternity benefits and how quickly those benefits might go away if the ACA were overturned. Lena, you want to jump in?
Sure, happy to. A lot of that, it depends on where you live. There are a number of states that have enacted contraceptive coverage requirements, no cost contraceptive coverage. There are 15 of them, but that has limited reach. Only fully insured plans, and so a lot of employer plans wouldn't be affected. It's not clear that all employers are going to drop contraceptive coverage per se, because many of them offered contraceptive coverage before, but we could see a beginning again, an increase in charges for out-of-pocket copays for the visits, as well as for the contraceptive methods. For the maternity benefits, there are also some states that require maternity coverage, but that again varies tremendously across the country, and it's only a handful of states. So that depends on the outcome of the case and how quickly all of this is implemented.
And I would just add, I mean, it was very common for pregnancy to be considered a pre-existing condition in the individual insurance market before the ACA, and that would once again be the case if the ACA were overturned.
Yeah, and I just do want to say that the Pregnancy Discrimination Act does protect women with employer-sponsored insurance and requires that they have maternity benefits. So we're really talking about the individual insurance market here, which is where a lot of women were really discriminated against before the ACA.
Well, as Cynthia talked about, there are the ACA is a sweeping law with many benefits beyond the health insurance changes we have primarily been talking about. One was gradually closing the Medicare donut hole. There was a question about how the ACA did affect Medicare coverage of drugs and what might happen to that if the ACA were overturned, which is a complicated issue that I'm going to let Tricia explain.
Well, thank you, Larry. People, when they talk about the ACA being overturned, they don't always think about Medicare, but the ACA actually touched almost every part of the Medicare program, and including prescription drugs. What people may have heard about is accelerating the closing of the infamous donut hole, and that was the gap in coverage in the standard benefit. The ACA phased down the closing of this coverage gap so that it wouldn't exist by 2020. What's interesting and different and hard to sort of anticipate in this particular case is the law was subsequently amended so that Congress spoke and accelerated the closing of the donut hole. So it's not entirely clear what would happen in this particular case if the ACA is overturned. But I suppose there is some risk that it could go back to pre-2010 law and have a gap in coverage, which could be higher costs for people. There's uncertainty about how that would play out.
Thanks. We had a question to asking to elaborate a little more on what the expansion in Medicaid in particular and the ACA in general has meant for racial and ethnic disparities in coverage and healthcare. Samantha, could you discuss that?
Sure. So we know that the Affordable Care Act coverage expansions, including both the Medicaid expansion and the marketplace coverage, led to particularly large gains in coverage for people of color that had helped to narrow longstanding disparities in health coverage. And we also know that health coverage is associated with improvements in access to and use of care. We specifically conducted an analysis of research that focused on the impacts of Medicaid expansion on racial disparities, which Robin alluded to in her remarks. This included reviewing 65 studies that examined the impacts of Medicaid expansion on racial disparities in coverage, access to care, and health outcomes. And what that showed is that the Medicaid expansion was really associated with narrowed disparities in health coverage. It also led to improvements in access to care for many groups and was associated with improvements in some measures of health outcomes for Black and Hispanic people, particularly around some measures of maternal and infant health. However, I think the studies and their findings really also show that coverage alone is not enough to really fully eliminate disparities in health and healthcare, and really points to the continuing importance of other social and economic factors in terms of driving health. So that while coverage is a key piece, it on its own is not sufficient.
Thanks. Well, as Mary Beth explained when she was describing the case, part of this case has to do with severability, whether the rest of the ACA can be severed or not from the individual mandate if the individual mandate is ruled unconstitutional. And we had a question about the functioning of the individual mandate and what effect repeal of the penalty in 2017 has had, and whether the mandate seems to be essential to the functioning of insurance markets under the ACA. Cynthia, you want to talk about some of the evidence there?
Sure. So the mandate penalty was zeroed out effective in the beginning of 2019. So we've now had 2 years of the exchange markets functioning without a penalty. And then plus we're looking ahead into a third year in 2021, where we're already starting to see what's happening with premiums and what insurers are expecting. So although the individual mandate was seen as being essential to the law, I do think it had some downward effect on premiums. Insurers say that they had to raise premiums, or the upward effect on premiums was about 5 percentage points when the individual mandate penalty was zeroed out. On net, at the same time, premiums have been staying very flat or even dropping in many states. And so I think what this shows is that the individual mandate was not as essential to the exchange market's functioning as a lot of people might have thought that it would have been. I think also what it shows is that a lot of people want health insurance, and it's just a matter of whether that insurance is affordable or not. So the subsidies and the ACA are doing a lot of the heavy lifting to keep the market functioning in a very stable way. So we've seen premiums stay flat. We've seen insurers actually enter into the market or re-enter the market when they had left before. I don't know if the court will take this into consideration or not, but at least as far as what the evidence is showing is that the individual market is doing just fine without the penalty being in place. I mean, there's certainly ways that the market could be improved, but this is where the individual market is where you would expect the damage to be done from not having a penalty, and we're not really seeing that play out.
Yeah, the only thing I would add is that we have seen big decreases in enrollment among people who don't qualify for subsidies in the individual insurance market. Enrollment among people who do qualify for subsidies has been quite stable, lending support for the idea Cynthia talked about, which is that the carrot of the subsidies has been more powerful than the stick of the mandate. And the big decrease in enrollment among people who are not subsidized could in part be due to repeal of the individual mandate penalty, but is likely in large part due to the fact that coverage has become so unaffordable for people who don't qualify for subsidies.
And that drop predated the repeal of the mandate penalty, or the zeroing out of the penalty. So there was already starting to be a drop, but there continued to be a drop. It actually wasn't as big of a drop as there have been in previous years.
Yeah. So there have been a few questions asking us to predict what the Supreme Court will do. I'm pretty sure we're not going to do that, but also some questions around timing and when we might expect a decision. Mary Beth, any insight into the schedule and when a decision might come down, and also kind of how things might play out following a Supreme Court decision, let's say, to invalidate the whole law?
Sure. So after the argument tomorrow, the justices will then meet and for the first time talk about the case among themselves and start to negotiate and see where the parameters of a decision are coming out. Like I said, in theory, the decision could come anytime because the case is officially submitted and ready to be decided. But we typically see in big cases like this that it takes a long time to get the opinions written, to get all the arguments hammered out. And so I don't expect that we will see a decision quite soon. I think it's more likely to be closer to the end of the term, which is typically at the end of June. And then in terms of what happens, the court is certainly aware of what's going on politically and that the administration will likely be changing its position in January and all those things. But the court will be not looking at that. They will be looking at the case before it. And so the question is whether the mandate right now is constitutional given zeroing out the penalty. And so I don't think they, in their legal analysis, will be taking into consideration the impact on what legislation, if any, Congress could pass subsequently. It's certainly possible that the court could recognize how ingrained the ACA is in the entire healthcare system and how very complicated it would be to untangle. And I think there have been some examples in the past where they might have given a very short time period, like 30 days or something like that, before the decision takes effect. However, I think that's quite unlikely. That's not usually how the court works. Usually, particularly when they're saying something's unconstitutional, the decision takes effect as soon as it's issued. So I think that is a really important question to watch as we see what the court does.
Yeah, I think that also is why a court decision to invalidate the ACA here could lead to rapid and widespread chaos in the healthcare system. Tricia, there was a question about Medicare Advantage and how the ACA affected Medicare Advantage and how an unwinding of the ACA, what that would mean for Medicare Advantage plans and beneficiaries.
The ACA included significant reductions in the growth in payments to Medicare Advantage plans. These are Medicare HMOs and PPOs that receive a payment from the federal government to provide Medicare covered benefits. So the ACA reduced future spending, and those dollars were used to help pay for coverage expansions. The effect of reversing that decision the immediate impact would be a significant increase in payments to Medicare Advantage plans. That would have huge spillover effects in a number of ways. It would raise premiums for everyone on Medicare because it would raise Medicare spending, but it would also accelerate the insolvency of the Medicare Trust Fund. And that's actually gotten to be a pretty serious issue because according to CBO, the trust fund is expected to be insolvent by 2024. So any change that raises Medicare spending, increases Medicare spending, which this would do if overturned, would have a bunch of consequences. I guess the only positive thing from a beneficiary point of view is there would be so much more money going to Medicare Advantage plans that it would likely result in lower premiums and more extra benefits.
And Tricia, what share of beneficiaries are now in Medicare Advantage plans?
A little bit more than a third, depending on how you count it. So it's a lot of people who are now in this part of the program.
Thanks. There's another question about some of the kind of less well-known parts of the ACA, this about the medical loss ratio requirement. Cynthia, could you explain that, kind of what is happening with loss ratios right now and what that means for rebates to consumers?
Sure. So the medical loss ratio rule in the ACA requires that if private insurers don't spend out a certain share of their premium income in the form of medical claims, i.e. if they keep too much as profit or administrative overhead, then they have to issue rebates to consumers. So this is the idea behind this, is to improve the value that health insurance offers consumers, and that it requires insurers to actually pay out money in health claims rather than keeping too much as profits or administration. In a typical year, there's not a lot of rebates that get issued because insurers can price appropriately. It may have initially kind of gotten some of the underperforming, so to speak, insurers into this target range, but since the initial year of the rule, there had been pretty flat, small rebates. But more recently, especially in the individual market, there had been a lot of uncertainty in the individual market. Insurers were unsure of what would happen if the ACA was repealed, or when the Trump administration came in and started talking about not making payments for certain types of subsidies. Insurers, I think, overreacted in the individual market and priced plans too high. As a result of that mispricing or overpricing, we've seen very large rebates to consumers in the last couple of years. Now, another issue right now is that because of the pandemic, and this is through no fault of insurers initially, going in, they wouldn't have known that there was going to be a pandemic this year. But the way they priced their plans was expecting utilization to be, similar to past years. What ended up happening as a result of the pandemic was that a lot of people went without healthcare that they otherwise would have gotten, either because they were afraid of catching COVID at the hospital, or because their elective procedure was canceled or delayed. And on net, what we're seeing is that insurers have been paying out much less in medical claims. Some of them have voluntarily waived premiums or even waived out-of-pocket costs for COVID treatment. I don't think they would have done that if it weren't for the medical loss ratio rule, because of the MLR rule, insurers have to pay back these high profits one way or another. So I don't know if they would have made these voluntary adjustments to their costs or to payments if it weren't for the MLR rule. Next year, we're likely to see, even though insurers have been making these adjustments or waivers, I think we're still likely to see that rebates are going to be very large next year. And they were already a record high of $2.5 billion, as CMS announced a couple days ago. I expect them to possibly be even higher next year. So obviously, if the ACA is invalidated, then those rebates would cease to be made.
And I would just add, it's if you look at, for example, short-term plans, which were expanded by the Trump administration and do not follow any of the ACA's rules, including protections for people with pre-existing conditions, essential benefits, this medical loss ratio rule, and consumer rebates, the loss ratios in those short-term plans tend to be much, much lower than ACA compliant plans, meaning much higher administrative overhead and much higher profits. And I think that's similar to what you would see in insurance plans in the individual market if the ACA were overturned. We've had a number of questions about sort of timing issues around what would happen to insurance if the ACA were no longer in effect, the effects of that on open enrollment, which is going on now. It started November 1st and runs through December 15th in most states, longer in some states that run their own health insurance exchanges. As Mary Beth explained, there's some uncertainty around how a ruling would play out and what its immediate effect would be. Insurance contracts are in place with current insurance rules. And there are some laws that even predate the ACA that determine how quickly an insurance company could cancel those contracts and potentially have to guarantee coverage in new insurance plans if those plans are canceled. Though no guarantees how much the premiums would be in those new insurance plans for people with pre-existing conditions. They could certainly be astronomical. But this would take some time to play out. Typically, insurance companies need to give several months notice before they cancel an insurance contract. People signing up now during open enrollment, insurance plans are month to month. So it's not like someone signing up during open enrollment now is committing to pay a premium in that insurance plan for an entire year in the event the ACA is overturned. Now, if the ACA is overturned and premium subsidies stop, many people buying their own coverage in the insurance marketplaces now would no longer be able to afford coverage if the ACA were not in place. But there is kind of little reason for people to hesitate signing up for coverage during open enrollment now because of the fear that the ACA might later be overturned. The question about back to Medicare Advantage plans and how increased payments to Medicare Advantage would negatively affect traditional Medicare premiums, whether there would be any carryover effect into the premiums that people pay under traditional Medicare.
Yeah, there would be a spillover effect because the way Part B premiums are calculated is it's 25% of Medicare Part B costs. Medicare Part B is the part of the program that pays for physician and outpatient services. So when anything results in an increase in Part B spending, Part B premiums go up. And so back to the issue of overturning the payment reductions that were in the ACA, if payments increased in Medicare Advantage plans, that's higher spending for Medicare Part B, which means higher premiums that would be paid for everyone on Medicare who pays a premium, whether they're in Medicare Advantage or in traditional Medicare.
Thanks. There's also a question about children's coverage and the extent to which the ACA did or did not affect children's coverage and what a court decision might mean. Robin, you want to talk about that?
Sure. Most of children's coverage is not affected by the ACA, but there was a provision to better align Medicaid and CHIP coverage and provide Medicaid coverage to all children up to 133% of the poverty level. So that was a change that would go away, and then states would have the option to allow some school-age children to be covered in CHIP beyond 100% of poverty.
Thanks. There are also a couple questions about kind of state and federal waivers under the ACA, both in Medicaid and in Medicare, and what kind of authority the ACA provided for demonstration projects in the states through Medicaid and then more broadly through Medicare. Maybe sticking with you, Robin, what kind of waivers have we seen? What would you expect to change under the Biden administration?
Well, some of the broader Medicaid waiver authority is not authority granted in through the Affordable Care Act. There are a few states that use waiver authority to implement their Medicaid expansion. So that would still be affected with an overturning of the ACA. So those waivers would be affected. And then there are broader demonstration waivers that are part of the CMMI program. And I'll let Tricia talk more broadly about some of those that are more delivery system reforms.
Sure. So CMMI is the Center for Medicare and Medicaid Innovations, and it was established under the Affordable Care Act to give the administration the authority to test new payment models, and they're occurring in Medicare and Medicaid and to some extent with private insurance. I could say that in Medicare, they have really opened up a floodgate of demonstrations to test different payment models that have now been embedded in the healthcare system. Think about ACOs, which are now covering people or insuring people with more than 10 million people on Medicare, bundled payments, all sorts of demonstrations that are reaching all parts of the country. So it's very complicated to think about what it would mean to eliminate the Center for Medicare and Medicaid Innovations and unravel these models that are really, as I said before, embedded in the healthcare system across the board. The idea behind these was to test to see whether payment reforms can help improve quality or lower costs. And that's an idea that has, sort of bipartisan interest, because it would obviously be important goals that I think both parties embrace.
And I just, Mary Beth reminded us through the chat that the ACA did include important transparency requirements for broader Medicaid 1115 waivers. So prior to the ACA, there were not requirements for a public comment period at the state and federal level. So to the extent that states are moving forward with Medicaid demonstration waivers, there are requirements for more public input and evaluation.
Right. I mean, I would also add, I think we should expect to see a big difference in how the Biden administration treats state waivers under Medicaid and state waivers under the ACA, assuming the law does remain in effect. The Trump administration, for example, has allowed states to impose premiums and lockouts in coverage under Medicaid, has imposed work requirements. The work requirements have been tied up in court, but I would expect to see the Biden administration reverse that kind of flexibility and offer new flexibility to move towards expanding coverage under Medicaid. Again, if the ACA remains in effect. The Trump administration has also given states leeway under what's known as Section 1332 of the ACA. For example, the Trump administration just approved a waiver in Georgia allowing people in Georgia, prohibiting people in Georgia from using healthcare.gov to sign up for coverage, and instead requiring them to sign up from private web brokers or directly from insurance companies. I would think again that the Biden administration would alter the kinds of waivers that states could use under the Affordable Care Act if the law does remain in effect. Tricia, there was a question about pre-existing condition protections in Medicare before the ACA and irrespective of the ACA. Could you talk about that, and also about Medicare supplemental plans and what kinds of challenges seniors face there?
Yeah, I mean, one of the great things about Medicare since its inception has been that people can do sign up for Medicare, become eligible and entitled to Medicare without regard to their income and without regard to their medical history. So Medicare has never run up against the problem of pre-existing condition exclusions. That's why you often hear about people who are in their late 50s and early 60s saying, I can't wait to get to Medicare, because they don't have to worry so much about this issue as they have had to do in the past with private insurance. Medicare Advantage, like regular Medicare, has no restrictions for people based on pre-existing conditions. There is one part of the market that has been left out, and I'm sure this is one Larry was referring to, which is the Medigap market. Medigap is regulated mostly by states, but to some extent by the federal government. And the last time Congress took a good look at the Medigap market was sort of before this whole discussion about pre-existing condition exclusions came in and before the ACA. So the Medigap market, which is what more than 10 million people purchase to supplement traditional Medicare, does not have the same guarantee issue protections as virtually every other form of health insurance that's available in the United States. This is the one part of the marketplace that hasn't received a whole lot of attention, and there are only 4 states that have laws in place that have guarantee issue protections and prohibit Medigap insurers from denying people coverage because of the pre-existing conditions.
Great. We had a question about Section 1557 of the ACA. Mary Beth, could you first explain what Section 1557 is and some of the recent controversy around the non-discrimination protections it provides?
Sure. So Section 1557 is a provision of the ACA that for the first time in some cases, such as sex discrimination, addressed when it is illegal to discriminate in healthcare. And so it extends not only to sex, but also race, ethnicity, citizenship, disability, a number of provisions. That particular provision, the regulations, I should say, under that provision are also tied up in litigation right now. So the Obama administration had issued regulations implementing 1557. The Trump administration then substantially rolled back those regulations in a number of ways. And that is being subject to court challenge right now. Some of those provisions have been stayed, so they are not yet in effect while the litigation proceeds. Others have taken effect. And so that's certainly an important area to watch. I will say, and this kind of goes to the severability question more broadly, it's not necessarily an all or nothing. The court could do severability more narrowly. So I think it was Chief Justice Roberts that said that typically the severability analysis is approaching with a scalpel, not a bulldozer. And so you try to preserve Congress's intent to the extent possible and take out just the offending provisions and any provisions that are inextricably tied to it. So for example, you've seen some taking the position that it's the mandate that is arguably, because of the findings in the original ACA, inseverable from the pre-existing condition protections, but not going farther than that. So how the court responds to that issue will determine whether it reaches broader things like 1557. And then I should also say that is the pre-existing conditions being tied to the mandate is one view. And as Cynthia alluded to, there is the opposing argument where you need to look at what Congress actually did. What they intended in 2017 is evident from what they actually did, which is just zeroing out the mandate and not going farther. And so the court should give credence to that.
Thanks, Mary Beth. Well, we're coming to the top of the hour and need to end it here. But hopefully this provided a good roadmap for what to look out for in the oral arguments tomorrow. And all the experts you see here on the screen are readily available on Twitter, and I'm sure we'll offer thoughts as the oral arguments proceed and this case rolls out. And as I said at the beginning, the fate of the ACA in many ways hangs not only on the Supreme Court, but also on those two Senate runoffs in Georgia, which would determine control of the U.S. Senate, and that will affect whether the Senate and the incoming Biden administration can make this court case moot, but will also affect more broadly President-elect Biden's agenda, sweeping agenda for healthcare, which involves building on the ACA, assuming it does remain in place. So thanks for joining us. Thanks so much for your questions, and we will see you online. Take care, everyone.